Hello, and welcome to today's session on information blocking. Today, we're going to talk about how to get your practice ready for this new regulation. Information blocking was passed as part of the 21st Century Cures Act back in 2016. It became effective as of April 5th, 2021. So today, what we're going to go over is what your practice needs to do to be ready for when enforcement starts. As with most things, there are going to be opportunities and burdens placed on your practice by this new law. You will have to have faster response times to patient requests for documents, along with continuity of care requests as well. There's also going to be more patients driven to the portal as they're able to get more information from your EMR. There are lots of government agencies involved with interoperability, which is the key component of information blocking. First and foremost is Health and Human Services. They are the overall agency that will be coordinating this effort. Underneath them, the Office of the National Coordinator for Health IT, or short, ONC. They are the ones promulgating the rules and going to be determining how it's enforced. It will be enforced by the OIG, the Office of the Inspector General. They are the same agency that enforces Medicare and Medicaid fraud. OCR, or Office for Civil Rights, will also be involved, as the patient access guidance is a big part of interoperability as well. And of course, Centers for Medicaid and Medicare Services play their role in information blocking as well. Always remember that the Federal Trade Commission, not a part of Health and Human Services, but all they have to come in and investigate you is an unfair trade practice. If you are information blocking, you are committing an unfair trade practice. So understand, there's going to be a lot of enforcement. In fact, the current administration has budgeted approximately $156 million for the enforcement of information blocking and patient access rights. So what is information blocking? Well, it's to interfere with the free flow of patient information, except as required by law or covered by an exception. It only has to be likely to interfere with the access, exchange, or use of electronic health information. We will interpret interference broadly, and it will take many forms. This was stated by the ONC. The ONC, on their website, listed some inherently suspect activities that would include interference with a patient seeking access to their own electronic health information, other providers requesting that information for continuity of care or treatment purposes. And you also have to be worried because information blocking could be when a payer tries to make sure that you are charging the proper fees and wants access to medical records for that purpose. As of the middle of August, the enforcement penalties for healthcare providers has not been determined. Expect them to be severe. As for the government's plan for information and interoperability to work, everybody's going to have to be a participant. Interoperability is a top priority for all of the Health and Human Service agencies this year. And to get started, the ONC suggests that you first perform your HIPAA risk assessment. That assessment now should include a risk analysis on information blocking as well to determine where you sit at this point. You are going to have to update your policies and procedures because the old policies and procedures most likely have provisions that are information blocking in them. And we're going to want to review all of your current business associate agreements along with the attached service agreements to make sure there is no language in there that would constitute information blocking. So where we've not had to update business associate agreements for quite some time, now most of your agreements will need to be updated and re-signed. So the ONC suggested that you update your risk assessment because HIPAA is still the backbone of the information blocking rule. Information blocking does not create any new access rights or remove any of the protections from HIPAA. And you also must be up to date with state and federal law restrictions and requirements. They are also unchanged. So that's, again, the good reason to get your risk analysis for HIPAA done with the new information blocking standards attached to it. So again, information blocking does not create or take away any of the current laws. such as minors' rights. Minors have the right in many states to withhold sexual health information. So if your portal automatically sends out an invitation to the parent when they give you their email address, that's going to have to be changed. Also remember that substance abuse laws are in effect and also prohibit the sharing of that information. The HIPAA exceptions that extend to information blocking are the preparation of materials for legal purposes in reasonable anticipation of or for use in a civil, criminal, or administrative action. And as always, psychotherapy notes have a special HIPAA protection. If you're unsure, please read the slide graphic to the right, going over exactly what a psychotherapy note is. Remember that psychotherapy notes can only be released to another provider with a signed authorization or with a court order, not a court subpoena. HIPAA's grounds for denial of access to a patient also extend to information blocking. Some of those unreviewable grounds would be such as when the patient requests their psychotherapy notes, for inmates of correctional institutions, and for those that are in a research study that have signed off that they cannot receive that information until after the study is concluded. Now, under reviewable grounds for denial are if the licensed healthcare professional feels that releasing the information is likely to endanger the patient or the patient could harm someone else. Those are reviewable grounds for denial, and they extend to information blocking. So the legal elements that the OIG must prove to find you as being an information blocker are one, that you're covered by the law, two, that you had the knowledge and intent to know that your practice was unreasonable and is likely to interfere with, prevent, or materially discourage the access, exchange, or use of EHI. I don't think that ignorance of the law is going to be a good defense because they have given you plenty of time to incorporate this before enforcement actually starts. So getting started. Step number 1, review your process for patient access to the portal. Is it automatic so that as soon as a patient gives you their email address, it automatically sends them out an invitation to the portal? Or do they have to request access? And then what is your process to do so and the time it takes to grant access to that individual? Also, review your process for peer-to-peer request. Other providers in the continuity of care chain that request records, how fast are we getting them those records? Step number 2, review the information that is pushed to the portal. When we set it up originally, we probably didn't set up the portal to get all of the patient information that we can push to it. Information blocking differs somewhat from electronic protected health information until May 2nd of 2022. So for the first year, the definition of EHI, what you must push to the portal, is the US CDI version number 1. We have that listed here on this page for you. So all of these items must be pushed immediately to the patient portal if they are contained in your EMR. Step number 3, review your methods to release records in other formats. We focus on the patient portal, but information blocking covers all of the EHI you hold electronically. So that would include releasing information in other digital formats such as CDs or thumb drives and email. Those are also going to be a part of EHI. Now, the paper records that you have still fall under HIPAA. Since they are not in your system electronically, they would fall under HIPAA, not under information blocking. Step number 4 is to review your business associate and service agreements. Many agreements have some form of information blocking language contained in them. Look for any restrictions or limits to information sharing. A sample common provision in business associate agreements is access to PHI within 15 days of a request. That in and of itself is information blocking. Well, what if that person or that business associate doesn't hold any PHI, such as our shredding company? Doesn't matter. Harm is not a requirement to find you guilty of information blocking. The fact that this provision is in your agreement makes you a possible information blocker. Step number 5 is to update yourself and your staff on the exceptions and the laws on medical record release. Again, information blocking has not changed any of those, but you need to make sure that you and your staff are up to date so that if you do need to block information, you know the proper way to do so, and that's going to be through documentation. Information blocking will require substantial operational and cultural changes within your practice. Again, for years, we have been permitted to share information. Now, information blocking states we are required and must share that information. The next few slides will go over examples of possible information blocking. So, practices that restrict authorized access, exchange, or use. Implementing health IT in non-standard ways. Limiting or restricting the interoperability of health IT. So if you have a patient portal and you have not opened it up for all EHI to flow to it, that is limiting or restricting the availability of EHI. That is information blocking. Other examples include acts that could lead to fraud, waste, or abuse. So again, it is the Office of the Inspector General who is enforcing this, and you do not want an information blocking claim to end up being a Medicare fraud claim. Restrictions on the access, exchange, or use expressed in contracts. So again, service agreements and business associate agreements must be updated. It's our office policy. No, if it's a formal policy that restricts information, you could be found guilty of information blocking. You cannot overrule with an office policy the law. Informal. Providing information in an unusable format. So if a patient requested on a CD and you have the capability to provide that, and instead you give it to them in another format, that could be information blocking. Again, disabling any of the operability that you do have is considered to be a possible information blocking. And isolated inferences here. A physician has the capability to provide same-day EHI access in a format requested by a provider or by the patient, but takes several days to respond. If your office cannot provide immediate access, and most can't, we should document what is reasonable for our practice. More examples given by the Office of the National Coordinator. Office policies that are more restrictive than HIPAA. HIPAA allows you to use an authorization, but does not require you for continuity of care. Now, under information blocking, if we know that the provider is a continuity of care provider for that patient, we are required. Creating any other hurdles to access or exchange EHI that can be broadly interpreted. Misunderstanding the law, claiming that a HIPAA restriction exists when it doesn't. So again, make sure you and your staff are up on legal claims to withhold information. Slowing or delaying information, or not entering the information into the EHR as fast as is reasonably possible. Timeframes provided by other laws. I got the records to the patient within the 30 days that HIPAA allows. No, if it's EHI, information blocking applies. Provider to provider request. Again, HIPAA permitted you to share that information. Under information blocking, it is directive and required that you share that information. The physician may want to review the records before releasing them to the patient. Maybe they do the draft record at the time of the visit and then sign off later. That draft note must be made available to the patient even before it is completed and signed by the physician. And a big problem right now is test results. If requested, the results need to be available to the patient as soon as you receive them, even if the physician has not had time to review them or discuss them with the patient. Again, the ONC stated that if you have the capability, you can push the records to the portal, and you're not, you would have to explain that. Contractual restrictions, again, checking those agreements, and materially discouraging a patient from accessing their medical records. A little bit different from educating them on the dangers of electronic access, but discouraging them would be considered information blocking. There will be many challenges with all offices to comply with these new information blocking rules and regulations. That's one of the reasons that they're giving us time now before enforcement starts. So if you're a pediatric office, you're going to have an inherent problem in that minor patients at a certain age by state law are allowed to withhold sexual health information. But if your process is to, once the parent or personal representative gives you their email address, for you to automatically send them out access to the portal, well, they're going to have access to that medication list, and they may see that the patient is taking birth control pills. So you're going to have to figure out a way to give portal access after it's checked by the staff. And then what if the patient is younger and then later turns older, and now the parent has this portal access as well? Again, you're going to have a lot of problems here with dealing with that. Contracts. Again, we've focused on business associate agreements and service agreements. Scanned records. Many EMRs do not allow for records that are scanned into your EMR to be available for reading on the patient portal. I think we're going to see that change very quickly. I know that some of the major ones already have added PDF and JPEG viewers to the patient portal so that they can see these records. Labs, pathology reports, no matter what your office feels, the current legislation states that the information must be immediately pushed to the portal, even if it's seen before the doctor has a time to review it. Another problem would be information told in confidentiality. Under HIPAA, a patient's family and friends could give you information that they do not want the patient to know that you gave them. And if you document that into the record, if they go to their patient portal, they may see that information was given from a source that was supposed to be held in confidentiality. The biggest question and controversy that we've seen so far with information blocking is the release of those lab and pathology results. And so do understand that the ONC has been very clear on when that information must be shared. Even though I just told you that you must proactively send lab and pathology reports to the patient portal, there was some controversy. In a FAQ published by the ONC, the question was, does the information blocking regulations require you as a healthcare provider to proactively make electronic health information available through the patient portal? Their answer in their FAQ was no. Based on information that the ACR had learned about information blocking, they quickly asked the ONC to clarify this and make sure that information did not have to be proactively sent to the patient portal. Upon reviewing the ACR's request, the ONC changed their statement. ONC clarified through this additional FAQ that to further illustrate, it also would likely be considered interference where a delay in providing access, exchange, or use occurs after a patient logs into a patient portal to access EHI that the healthcare provider has, including, for example, lab results, and such EHI is not available for any period of time through the portal. That states you must proactively send that information to the patient portal. Knowing the exceptions is a key component in your efforts not to be an information blocker. First of all, understand that the ONC stated that there are no blanket exceptions. We can't make a policy. It has to be tailored to a case-by-case manner, and it must be consistent. We cannot provide our affiliates with faster or easier access than we do providers who are not part of our network. Exceptions must be thoroughly documented. And for each exception, no matter which one applies, they must be reasonable and necessary. They must address a significant risk, and you must document both of those on the forms. In our review of the information blocking exceptions, we're going to go over two different categories. One, when you are not fulfilling the request for EHI, and two, when you will be fulfilling the request for EHI. It's important for you and your staff to be fully up to date on HIPAA, because many of the exceptions follow the HIPAA rules and regulations. Preventing harm exception. Here, practices that are reasonable and necessary to prevent harm to a patient or another person, provided that other conditions are met, is a defense for information blocking. Proper and comprehensive documentation is required to meet any of the exceptions, and therefore our information blocking kit has the forms going through the requirements of each exception. So make sure that you fully go through the actions that are required by statute and document them in your exceptions blocking document. The privacy exception. Practices implemented to protect the privacy of EHI based on HIPAA are not going to be information blocking. So a good example, the pediatric patient. You could apply the privacy exception because you cannot release through the portal the patient information because there's no way to segment out the protected information by state law. You will have to use the exception form for privacy, again, filling out the reasonable and necessary and the significant risk, and then going through again the process outlined by the statute through our form. The security exception. Practices implemented to protect the security of EHI, as long as the measures are specifically tailored to the security risk and implemented in a consistent and non-discriminatory manner. So some of the elements to document are that the denial must be directly related to safeguarding the confidentiality, integrity, or availability of the EHI, be tailored to the specific security risk reviewed, must be consistent and non-discriminatory, and again, must list the organizational security policy, HIPAA, that you are implementing. The health IT performance exception. Sometimes technology will be temporarily unavailable for maintenance or updates, and you must document that if a patient requested the information during that period, that you applied the health IT performance exception. You would use this document to document the health IT performance if a patient were to call and complain that they were unable to access their patient portal, and it was a time when the system was being updated. So you would basically document, again, the reasonable and necessary, the significant risk, and that the denial was for no longer than the period of time that was necessary for that performance or update to take place. The infeasibility exception is for denying request for EHI when fulfilling that request is objectively and verifiably infeasible. For the infeasibility exception, you will need to document that there were uncontrollable events that led to you not being able to fulfill the request for access, exchange, or use of EHI due to natural disaster, public emergency, public safety, war, or other reason that interrupted service. There is also an exemption when fulfilling request for EHI, but a limited request. There, you are going to use the content and manner exception. You are limiting amount of the EHI content based on request for access, exchange, or use in a way that fulfills the request in the manner that you can refill that request. So an example here is, again, that pediatric patient. You may not be able to give the parent or personal representative access through the portal because there's no method to segment the information that is allowed to be protected under state law. But we could offer the content and manner exception to give the parent or personal representative paper records where you could redact the information that the parent or personal representative is not allowed to access. Again, documentation is key, and you want to make sure that you fully document the content and manner exception information. Other exceptions that will not apply to you as a healthcare provider include the fees exception and licensing exception. If you do apply an exception, the patient must be notified within 10 days of the applicable law or the exception that you are using to deny access. Again, we prepared a simple and quick letter for you to send out to that patient within that 10-day time period. It is highly recommended that you educate patients on their portal access, letting them know when it's going to be available, how it's available. And they should also understand that giving out their username and password would enable others to see their full patient information that is available through the portal. You may also want to warn them that lab results and imaging results may be included before the doctor has had a chance to review them and sign off on them or to communicate them to the patient. They should also understand that they should not change their medication or treatment plans until they discuss what they've seen with a medical professional. How does information blocking apply if your practice does not have a patient portal? Well, we need to review that. Number one, do you have a portal but have not enacted it, have not turned it on? In that case, that could be information blocking, so we definitely want to turn on that portal. But perhaps it's an additional service that we've not paid for, or because our EHR does not have one, we would have to go through another third party. Not having one is not information blocking at this point. Remember, though, that just because you do not have a patient portal does not mean information blocking does not apply to your practice. You must still have the documentation to show that you are fully complying with information blocking. So without a patient portal, you're going to need to speed up your other access to patients and other providers for any information that is kept in your EHR, even if you are providing it via paper, email, or other digital records. Again, make sure that all your compliance efforts are documented and kept for at least a period of 6 years. A note here, I do believe that information blocking is not going to be as severe with the patients because for the most part, many patients still do not use the patient portal. But again, remember that information blocking also applies to continuity of care providers. This is one of the biggest complaints we get from our practices is that other practices either will not or are very slow to release medical records. That now will be considered information blocking, and so I expect a lot of provider to provider documentation to the ONC of claims of information blocking. That concludes our Getting Ready for Information Blocking video today, and we ask that if you have any questions that you submit them to us. We can be reached at mm@HIPAAcompliancekit.com for Michael McCoy, and also that you watch our other video, which is a longer training video on fully implementing information blocking into your practice. Thank you for your time today. Again, please feel free to contact us.